Hi everyone, my name is Kenneth Matuszewski and I am a member of the ISBA's Intellectual Property Law Section Council. Today's video will be continuing and expanding a video in my first series, the Intellectual Property Basics. And we are going to be explicitly and specifically discussing patents. So many of you may know that patents are used to protect inventions. But did you know that there's actually multiple types of patents? We have what's known as utility patents, that are the more traditional patents, and then we have what's known as design patents. This video today is going to be discussing both of those different types of patents. Before we begin, I wanted to give 3 little quick tips. First, utility patents protect inventions, or, in other words, how it works. 2, design patents protect designs and products in terms of how they look. And 3, utility patents and design patents are not mutually exclusive. And in fact, for a single product, you may actually be able to get both a utility patent and a design patent. Utility patents and design patents have many of the same requirements for obtaining patents in general. First, it must be eligible subject matter, which is generally pretty easy to do. Second, there can't be something out there that has all of the exact features or logos or patterns as your design or your invention. And third, it can't be obvious. So obviousness is generally a pretty murky concept, but the best way to think about obviousness is that it can't just be the next step in the product's development cycle. So for example, you can't obtain a patent on a higher run speed of a phone because, well, you already have the phone and you already have internet speeds, and just having it run faster is just generally a part of the next steps and how you would just generally improve the phone's functioning. Now, utility patents have what's known a little bit kind of on the nose and in the name is a utility requirement. And the utility requirement just asks this one question. Is it useful? And apart from serving as maybe a literal garbage heap, you can think of any possible use. It doesn't have to potentially even be it could be as small as possible. As long as it can be used for something, then it has utility. A design patent then has, instead of this utility requirement, what's known as an originality requirement. In other words, there can't be some person, place, character, or thing that you can base the design off of. So the design must be completely new. It cannot be based off of anything in real life or in fiction. Design patents are also a little bit cheaper and quicker to obtain than utility patents. It takes about 19 months for a design patent to issue or to reach a final action with the USPTO, while a utility patent takes around 2 years for it to reach that final action at the USPTO or to issue. It's also cheaper to obtain a design patent than it is to have a utility patent. So if your goal is really to have the benefit of patent pending and of marketing, and if you really just want intellectual property protection really fast, then a design patent is actually pretty good for that. But you can actually combine both of them into one. And by combining both of them into one, what I mean is that you can have both the utility patent and a design patent for the same product. So for example, let's take a coat hanger, and someone invents a coat hanger that has a new heating pad on it. So when you put your coat on it, that the coat will be heated and you will feel warm once you put your coat on. So someone could obtain a utility patent for this coat hanger that can hang up clothing while also warming them at the same time. That is the function of the coat hanger. It not only hangs up clothes, but it also heats it up. You could obtain a design patent for the way that could look. So whether it might be a traditional coat hanger and maybe it has a little heating pad on it, or maybe there's some little just ways that it looks different than a traditional coat hanger. you could obtain a design patent for that. So, generally speaking, there's a lot of key considerations when you're obtaining intellectual property. But knowing that there's several options out there, such as design patents and patents, can give you and your clients a little bit more peace of mind in terms of figuring out a strategy on how to protect your intellectual property. To learn more about the benefits of joining our ISBA Intellectual Property Section Council, please visit the ISBA website.